You will have 15 minutes to argue.
Thank you. On behalf of my client, I thank you, all the three judges, for your professional courtesy extended to me in this case. May it please the court, my name is David Schell, and I represent the appellant Stephen Knight. I'd like to direct this court's attention to my second assignment error in the appellate brief. And that error involves the testimony of Deputy Sauer being permitted by the trial court in this particular case. And the argument being that Deputy Moore testified as a expert in this particular case. The state concedes in its brief that in fact this testimony was expert testimony. It begins by saying it wasn't, that it was lay opinion testimony, but then went on to cite several appellate cases that specifically state this is knowledge beyond the average layperson's knowledge, so it's not common knowledge. So the state concedes its expert testimony. The issue before this court is whether or not the court's going to do a plain error analysis in this case, and I'm asking the court to do that. And the reason I'm asking the court to do that is because in 2010, the rules were amended. The open discovery rule, Rule 16, was amended. Before 2010, there was no requirement on behalf of the state of Ohio to submit an expert report 21 days in advance of trial to disclose those expert opinions, etc. The only requirement before 2010 was if you were going to call anybody to testify about examinations or tests, etc., there was a specific requirement of disclosure under the Rule 16 about that particular person's expert opinions. So before 2010, there was no requirement. After 2010, there was. It's the position of the appellant that that's significant in this case. The reason it's significant is when this testimony came about, I don't believe that trial counsel was prepared for this, as trial counsel would have been prepared had an expert report been disclosed 21 days in advance of trial. Trial counsel did object, although not specifically on these grounds. Did not object that this was expert testimony, that he had not received an expert report. He objected on foundation. He objected, I believe, on hearsay. And I believe there was another objection, I can't recall from the record or the transcript what the third objection was, but they were all interspersed during the deputy's testimony and when the deputy was offering these expert opinions. Those specific opinions dealt with Eric Fink's, the alleged victim in this case, delayed reporting, continued contact with my client, Mr. Knight, and the fact of this unbreakable bond in terms of gifts, etc., that were given to him. The test, if this court was to notice plain error on this issue, is whether or not the prosecutor's violation of this rule was willful, whether or not that had the trial counsel, Mr. Winchell, been advised of this evidence in advance of trial, whether or not it would have benefited his client. I submit to the court, obviously it would have benefited his client. He could have went out and hired an expert on his own. He could have reviewed peer-reviewed literature as to whether or not those opinions by Deputy Sauer were accurate, whether or not he could have challenged those opinions through an expert, and whether or not there was material prejudice or prejudice to him. I submit on the issue of prejudice, he was prejudiced. The jury returned a guilty verdict based on the determination of whether or not who was more credible in this case, Eric Fink or Stephen Knight.
Well, but is that really the beginning and the end of the analysis? Because another part of the analysis, I don't think that it's limited to the fact that the jury found him guilty. There was physical evidence. There were, voice messages. There were text messages. There was the testimony of your own client. And so what we're being asked to look at here is the extent to which the deputy's testimony on matters that are outside of the common knowledge of the jury actually contributed to or caused him to be found guilty.
Thank you, Judge Moore. I believe it did. And the reason I believe that, and it goes back to the first element in order for this court to reverse on prosecutorial withholding and not giving an expert report, and that's whether or not it was a willful violation. I submit to this court that the prosecutor, that this was a willful violation, and here's why. The prosecutor knew in advance of trial she had to deal with these three issues, okay? Those three issues being, why did the victim not report this immediately on November 4th or shortly thereafter and wait till February 15th of 2015? Number two, why did the alleged victim, Eric Fink, continue to have contact with my client if he was sexually abused by Mr. Knight? Why did he continue to see him? Why did he continue to have communications with him? And number the third one was, why, I think that's, I'm sorry, in my brief I indicated the third one being how the giving of gifts by the abuser to the victim creates an unbreakable bond between them. The deputy testified about that. And the prosecutor knew all of these things in advance of trial, and the prosecutor had to deal with those issues. So what did she do? She addressed them through Deputy Sauer and qualified her as an expert so she could deal with those issues because she knew that this case was a credibility case.
Well, did the, I read in the brief the questions that were asked of the deputy about training and experience and how much of her time was devoted to cases of this nature. At the end of that, did the court say, I'm making a ruling that you may testify as an expert, or did the examination just go on?
Examination just went on, Your Honor.
And to that point, that even you've acknowledged there's a line of cases in which the courts hold that a police officer may give lay testimony if it will assist the jury in issues that may be beyond their common knowledge. Is there an inconsistency between having an officer testify to those issues? Let me back that up. If an officer testifies to issues that would assist the trial of fact, does that necessarily mean that the officer is testifying as an expert witness?
Yes, if those issues are beyond the common experience of lay people. And in this case, they were. Because if a lay person, simply put, common sense says, well, if this person was abused by this other person, why didn't the victim immediately report it to the police or authorities? Well, why is that? Why did they wait 3 months? That goes to the issue of a juror saying, well, maybe the victim's not telling the truth. Oh, wait a minute. Now, we have an explanation for that. Deputy Sauer says this is not uncommon, and here's why it's not uncommon. Likewise, with respect to the continued contact, she specifically went into that issue about continued contact with the abuser. Why is there continued contact? And this is an issue that actually was explained away by the alleged victim, Mr. Fee. He explained that he didn't immediately report it. Number one, he didn't immediately report it because he felt, he talked to Mr. Knight, and Mr. Knight felt ashamed, embarrassed, so he decided not to report immediately. Well, that goes against why then Deputy Sauer is testifying on that issue. The other issue was continued contact. Deputy Sauer specifically explained in her experience that victims feel powerless, they feel ashamed, and they still have continued contact with the abuser, and that's not unusual.
Well, outside of her explanation, I'm just thinking about the record before us. There was testimony, I think, that was unrebutted, that your client gave gifts, significant gifts. I'm wondering whether or not the trier of fact may have been able to consider that independently of the testimony of the officer that you claimed was expert as a reason why the young man would continue to have contact with your client.
Well,
There was a financial incentive.
right, and I think, Your Honor, in this case, I think that goes to the issue of material prejudice. I think it's hard to distinguish. Once they hear that testimony, they're given an explanation why these gifts are given, etc. But there was also testimony, if you recall from the transcript, and I believe it was from his wife, Patricia, that he gave gifts to several students, not just to the alleged victim, Eric Fink. So, but they hear he gives gifts to other students, but then they hear he gives all these gifts to Eric Fink, and then they hear, well, Deputy Sowers says that creates this unbreakable bond between the abuser and the victim when they continue to give gifts to him, et cetera, to maintain that hold over the alleged victim. And in this case, I mean, it was, I think, the day or next day, and this goes to the credibility of Eric Fink, he's asking for money. He's saying, give me money, $2,000, I'm going to Mississippi, I'm gonna live with so-and-so, I'm gonna put this whole matter behind me, da-da-da, give me money. And Mr. Knight gives him money. So, you know, that can be interpreted two ways. That's part of the unbreakable bond that Deputy Sauer testified, or he's got an incentive to use this money as a hold over my client in terms of, hey, I know it was an accidental touching, but give me the money, and maybe in his mind he's thinking, if he doesn't give me money, I'm gonna go and report this to authorities that, you know, he molested me, when in actuality he didn't. That this
Or
was
a
a,
third option is you buy him off.
buy him off to what extent?
Well, if you commit a crime and the victim, you know, you realize it and you hoping that the person doesn't prosecute you.
Judge Guy would agree with you, except for this fact, that it wasn't an offer by him, it was a request by the.
Well, either way, there's many ways of looking at that, just like you said.
I think it would be much more powerful, your innuendo would be much more powerful, or inference would be much more powerful if my client said to him, hey, I'll give you $2,000, use it out as you want, you don't have to pay me back. But actually, in this case, there was testimony he expected to get back, and Eric Fink did not pay him back the money. So I think it's significant in this case about Deputy Sauer's testimony, because all these issues, the three assignments I raised, are intertwined. And in the first one, the 404B inference, as you recall from the transcript, when the prosecutor asked Eric Fink, why did he make reference to the video recording, Eric Fink testified, he says, well, he would just deny it. So therefore, you know, I testified that this has been going on for a while now. The judge interpreted that as being a reference to the videotaping, that he had been videotaping for a while now. He, you know, he can't deny it had been videotaping. The other inference, and the inference I believe, and that's why counsel objected at trial, was, hey, this has been going on for a while now, being ongoing abuse. That intertwines with the whole argument with Deputy Sauer's testimony about how there's continued contact, et cetera. And when you couple that with, this has been going on for a while now, created the inference, or I think the jury could have inferred from that, this is just not an isolated incident of Mr. Knight touching this guy, this person, Eric Fink. This has been an ongoing incident, and Deputy Sauer's testimony contributed to that. We have gifts, we have continued contact, et cetera. They hear that testimony from Eric Fink as with respect to the 404B. You couple that, it becomes very powerful, I think. I mean, these issues are all intertwined, too.
Well, let us assume that we agree with you that the testimony of Mr. Fink was designed to, or what it meant was that this touching has been going on for some time. Let's just assume that that's what the jury thought when the statement was made, even though it was a very brief, I think maybe 8 words that were said. It wasn't even a sentence, it was a clause. And if, let us assume that when the jury heard that, they had some misgivings. Well, the trial court then reads that differently and gives a specific instruction to the jury as to how they're to consider it. You know, we've said forever that once the trial court gives instructions, we have to presume that the jury follows those instructions. So the trial court said, no, this is what that meant, and this is how you are to interpret and consider that in your deliberations. Where do we go from there in seeking reversal?
Judge Moore, that's a good question, but I think in this context, the judge is specifically usurping the province of the jury by saying this is the only interpretation you can make from this statement of Eric Fink, which I think the jury's free to conclude otherwise, even with that instruction. Meaning, if trial counsel would have gotten the benefit of the doubt and gotten the 404B curative instruction, then I think I can't stand here and argue. If the court specifically would have said, this is 404B evidence, this is not used to show the character of the accused, but it's used to show whatever one of those exceptions is, and I mentioned in my brief, and why it's not accident, or goes to the issue of accident, because he testified he accidentally touched him, but the court could have given a 404B curative instruction and said to the members of the jury, look, this does not go to the person's, the accused character, this is used for the sole purpose of establishing one of the following, purpose, motive, intent, da-da-da-da-da, and I think end of the matter. I could not be standing in front of you and arguing this as an error in this particular case. But
And counsel, your time is up.
thank you for all the reasons stated in my brief. I would respectfully request that the 9th District Court of Appeals reverse the judgment of the trial court and return this matter to the trial court level for a new trial.